I'm Stephen Gould and I wrote Return of Breaking Law.
Why are you talking so fast?
Because time's running out before the 13th of this month, July, and that's when a raft of court and tribunal fees are being increased, 170 by 2.8% and 27 by an average of 34%. If anyone needs to take a step in a court or tribunal case that will generate a fee, then take it before the 13th of this month and make a small saving. You can access lists of the affected fees by clicking on the link with my fact sheet. There are a couple of them so as to whet your appetite. Making an application in county court or high court civil proceedings, which may require a hearing, will cost £321. Landlords seeking possession of a residential property through the county court will now shell out £415 instead of £404. Starting a divorce, nullity or civil partnership dissolution case will cost an extra £16 at £628. And here's the whopper. The fee for applying for probate or letters of administration where there's no will is going up by 75% from £300 to £526. So if you apply before the 13th of this month, you'll make a saving of £226. If you've got a solicitor or other professional acting for you in the winding up of a deceased person's estate and they're ready or almost ready to make the necessary application, ensure they pull their fingers out and beat the increase. As always, those on benefits or low incomes can take advantage of the Help with Fees scheme and should be able to secure a waiver or reduction of any of the fees we've been talking about. Hands up anyone who has a complaint about how their data has been used. Right, 10 trillion, 10 trillion and 3, 10 trillion and 24. Okay, hands down. If your complaint arises on or after the 19th of June 2026, that's last month, then instead of taking it to the Information Commissioner under a new statutory scheme, you can go directly to the organisation that you say has transgressed. The organisation must acknowledge the complaint within 30 days of receipt and take appropriate steps to respond and inform you of the outcome of the complaint without undue delay, they say. Should the organisation fail to acknowledge or deal with the complaint as it should, you can escalate it to the Information Commissioner. Good luck. Expecting the sack? Well, the time limit for making an unfair dismissal claim to an employment tribunal is set to be doubled to 6 months on the 1st of October 2026 for dismissals on or after that date. But ask the boss to hold on. Under legislation just made on the 1st of January next year, 2027, the limit on what you can be awarded for unfair dismissal is scrapped, so bigger awards if you can prove bigger losses. And an employee will only need to clock up 6 months in the job before unfair dismissal can be claimed instead of the current 2 years. If a claim to an employment tribunal is contested by the boss, then don't expect a hearing overnight. There are reckoned to be around 65,000 cases awaiting a hearing, an increase of 43% in just 1 year. It can only get worse. Take this scenario. The family home is owned by husband and wife. Husband's made bankrupt. There's equity, money, in that home, which the husband's creditors want to get hold of towards what they're owed. Well, the court can order the home to be sold and the husband and wife to vacate it so as to facilitate that sale. But the wife wants to stay put.
Can the wife be forced out?
Well, at some point, yes. And let me make it clear that the relevant law will also apply where it's the wife who's been made bankrupt and the husband wants to stay put, or we're talking about cohabitees or same-sex couple involved.
So when can she be forced out?
Well, generally, once 1 year has passed since the bankruptcy. However, the court does have the power to extend that time where there are exceptional circumstances. The court will decide on the wife's application for more time, and how it would go about deciding has just been reviewed in a High Court case where the wife was given an 18-month extension rather than the 8 years that had been granted by a lower court. The exceptional circumstances will usually relate to the personal circumstances of one of the owners, such as a medical or mental condition. The fact that the sale of the home won't produce sufficient to enable the wife to buy a comparable or any home for herself and children won't rank as an exceptional circumstances, nor will the fact that the whole sale proceeds will go towards the expenses of the bankruptcy. And what this latest case establishes is that the court, when deciding on exceptional circumstances, can look at the circumstances leading up to the making of a bankruptcy order, so long as that's not unfair to the creditors. Other relevant factors will be the circumstances of the creditors. Are they global businesses with money pouring out of their coffers, or backstreet traders on the breadline? Whether the wife has contributed to the bankruptcy, too much online spending, and the needs of any children. A wife and so on who is a co-owner of a home, whether they're on the title deeds or can show they have a proprietary interest in it without being on the title deeds, won't be robbed of their share in the sale proceeds. It's only the bankrupt's interest that can go towards paying off their debts. Debtors who attract a county court judgment know all about the register of judgments, orders and fines. Details of the judgment are recorded on the register, which is open to the public for a fee and maintained by Registry Trust. And the details stay there for 6 years unless the judgment is settled within 1 month and then cancelled at the debtor's request, or the judgment is set aside because, say, the court is persuaded that the debtor had a good reason for not putting in a defence to the claim in time, or the court paperwork never reached the debtor due to it having been eaten by the dog. If the debtor settles the judgment outside 1 month, they can still ask for that fact to be noted on the register. There are exceptions to registration, including cases where the claim was contested by the defendant. Registration, when it happens, is likely to kill off the debtor's prospects of obtaining credit or a mortgage advance. So, at long last, one in the eye for the claimants who do all the suing and obtain the judgments. Up till now, the identity of the claimant hasn't been revealed on the register. From the 20th of this month, July, it will be included in the details of the judgment sent by the court to Registry Trust, and from the 20th of October 2026, it will be included on the register and be available to be seen by the public. Claimants who are shy of the extent of their activity in the courts won't be amused. Those who need to be regulated by some authority will be aware that excessive or aggressive litigation may be frowned upon by the regulator. And claimants can be expected to have to deal with inquiries from defendants who've been sued and were ignorant of the proceedings and want to get from them information about the case so that they can ask to have the judgment set aside. Is that Whitewash & Co Limited? This is Clive Troublesore here. What's this about you suing me last year in the Toy Town County Court for $6,000 for a box of paper clips? You sent the claim form to the wrong address. I said the wrong address. Is anybody there?